There is a phrase that sounds like science, but isn't. The phrase is, the odds of this happening by chance are 1,000,000,000 to 1. When an expert witness says this in a courtroom, calmly with credentials, in the language of mathematics that most jurors have been trained to trust, it lands with enormous force. Numbers feel objective. Statistics feel certain. And certainty in a courtroom is what convictions are made of. In the spring of 2003, a statistician named Dr. Eleanor Marsh took the stand in a Bristol, England courtroom and told the jury that the probability of Warren K's being innocent, given the specific combination of financial evidence against him, was, in her professional assessment, approximately 1 in 800 million. The jury believed her. They had been given every reason to. Warren K's, a 38-year-old financial analyst named, in our story, Vanessa Torres, was convicted of embezzling from her employer, sentenced to 12 years, and entered the British prison system carrying a statistical verdict that felt as solid as stone. The problem was that the statistic was wrong. Not slightly wrong. Profoundly, catastrophically, fundamentally wrong. In a way that a competent statistician would have caught. In a way that had been documented in academic literature before the trial. In a way that the prosecution's expert had simply not accounted for. Vanessa Torres spent 18 years in prison before a mathematics professor reading a case summary in a legal journal put down his coffee and said, "That cannot be right." This is the story of the prosecutor's fallacy, of the number that hanged an innocent woman, and of how the most trusted language in a courtroom, the language of mathematics, can be the most dangerous when it is misused. Vanessa Torres was 38 years old in 2003. She had grown up in Bristol, the daughter of a Spanish mother and a Jamaican father, raised in a household where education was not optional and precision was considered a virtue. She had studied mathematics at the University of Bristol, graduated with first-class honors, and spent the following 14 years building a career in financial analysis, first at a medium-sized investment firm, then at a larger asset management company called Meridian Capital, where she had worked for 6 years by the time of her arrest. She was, by every professional assessment, exceptional at her work. Her models were clean. Her projections were consistently accurate. She had a reputation for finding errors that others missed, the kind of analyst whose work other analysts quietly checked their own work against. In early 2002, an internal audit at Meridian Capital identified a series of irregular transactions totaling approximately £2.3 million. The transactions had passed through accounts that Vanessa had primary access to. The pattern of the transactions was consistent, the audit concluded, with deliberate embezzlement. Vanessa said she had not made those transactions. She said she had no explanation for them. She said her access credentials had been used, but that she had not used them. This was the beginning. And the end, it turned out, would depend almost entirely on what a statistician said about the beginning. To understand what happened to Vanessa Torres, you need to understand a concept called the prosecutor's fallacy. The prosecutor's fallacy is a specific error in statistical reasoning that has appeared in courtrooms around the world for decades. It is seductive because it sounds logical. It produces numbers that feel like certainty. And it is wrong. Here is the basic version. Imagine you are told that the probability of a specific pattern of financial transactions occurring by random chance is 1 in a million. A prosecutor then argues, therefore, there is only a 1 in a million chance that the defendant is innocent. This is false. It is false because it ignores a crucial question. Out of how many people could this pattern have occurred? If you are looking at the transactions of 10,000 employees, and each one has a 1 in a million chance of producing this pattern, you would expect to find the pattern roughly 10 times in 10,000 employees. Finding it in one person does not make that person a 1 in a million suspect. It makes them one of the roughly 10 people you would expect to find it in. This error was formally described and named in academic statistics literature in the 1990s. It had been identified as a serious problem in forensic and legal contexts before Dr. Eleanor Marsh took the stand in the Vanessa Torres trial. Dr. Marsh was a qualified statistician with genuine expertise. She was not, as far as anyone has determined, acting in bad faith. She had conducted a legitimate statistical analysis of the transaction patterns. What she had failed to account for was the baseline, the question of how many people in Meridian Capital's position might have been expected to produce a similar pattern by chance, given the complexity and volume of transactions involved. Her calculation gave the probability of the pattern occurring by chance in Vanessa's specific accounts as approximately 1 in 800 million. She presented this as the probability that Vanessa was innocent. These are not the same thing. They are not even close to the same thing. But in a courtroom, to a jury with no training in probability theory, they sounded identical. And the number, 1 in 800 million, settled over the courtroom like a verdict in itself. The trial of Vanessa Torres opened in April 2003 in Bristol Crown Court. It lasted 3 weeks. The prosecution's case was built on 3 pillars: the transaction records showing the irregular movements, Vanessa's access credentials as the primary authorized user of the relevant accounts, and Dr. Marsh's statistical testimony, placing the probability of innocent explanation at 1 in 800 million. The defense challenged each pillar. They argued that access credentials could be shared or stolen, that having primary access to an account did not mean being the only person who could use it. They pointed to gaps in the company's IT security protocols. They noted that the transactions had been identified in an internal audit, raising the question of why someone embezzling money would leave traces so visible that a routine audit would find them. They also challenged Dr. Marsh's statistical analysis. The defense had engaged their own statistician, a retired university lecturer named Dr. Peter Walsh, who testified that Dr. Marsh's calculation contained a fundamental error, specifically that she had not accounted for the base rate, that her figure was the probability of the pattern occurring in Vanessa's accounts, not the probability that Vanessa had created it. Dr. Walsh's testimony was correct. It was also complex, technical, and delivered by someone who, unlike Dr. Marsh, seemed uncertain in his delivery. The specific uncertainty of someone who is trying to explain a subtle distinction to people who lack the background to evaluate it. Dr. Marsh had a number, 1 in 800 million. Dr. Walsh had an argument about why the number was the wrong number. In a courtroom, a number almost always beats an argument about why the number is wrong. The jury convicted Vanessa Torres on all counts. She was sentenced to 12 years in prison. She was 39 years old. Her mother was in the courtroom. Her mother did not cry. She sat very still and looked at her daughter and said nothing. Later, Vanessa said that look, that absolute stillness, was the thing she carried with her into prison. Vanessa Torres served her sentence at HMP Downview in Surrey, and later at HMP Send. She was transferred twice, for reasons of prison population management that had nothing to do with her case, and each transfer meant new procedures, new relationships built from scratch, new adjustment to an environment that the British prison system had not designed for long-term wrongful convicts who happened to have a first-class mathematics degree. She used the mathematics degree. She taught informal classes to other inmates. She helped women in the prison prepare for numeracy qualifications that would be useful on release. She read everything she could find about statistics and law. Specifically, she read everything she could find about the prosecutor's fallacy and about cases in which statistical evidence had been wrongfully applied. She found in her reading that she was not alone. The prosecutor's fallacy had appeared in British courtrooms before. It had been identified in a high-profile case in the early 2000s involving sudden infant deaths, a case where a statistician's error had similarly resulted in wrongful convictions. Those convictions had eventually been overturned. The statistical error had been publicly identified and condemned. She filed an appeal in 2005, citing the same statistical error in her own case. The Court of Appeal reviewed it and declined to overturn the conviction. The court's reasoning was that the statistical evidence had been one component of the prosecution's case, and that even if that component were flawed, the transaction records and access credential evidence remained. The overall conviction was, the court found, sound. Vanessa read this judgment in her cell, and then put it down and looked at the wall for a very long time. She had served her 12-year sentence and been released on license in 2015. But the conviction stood. She was a convicted fraudster in the eyes of the law, which meant her professional career was gone, her financial analyst credentials were worthless, and every job application for the next 3 years resulted in the same outcome. She continued fighting, from outside the prison now, but fighting the same battle, to have the conviction overturned, not merely the sentence served. To have the record say, not guilty. To have the mathematics corrected. In the autumn of 2019, a mathematics professor named Dr. James Adeyemi at University College London was reading a legal journal. Not his usual reading material, but he had been asked to contribute to a multidisciplinary seminar on statistics in the courtroom and was doing background research. He came across a brief summary of the Torres case in an article about wrongful convictions involving statistical evidence. The article mentioned the 1 in 800 million figure and described the trial in general terms. Dr. Adeyemi put down his coffee. He read the paragraph 3 times. Then he opened his laptop and started working through the calculation. It took him 40 minutes to confirm what he had suspected immediately. The calculation, as described, was a textbook example of the prosecutor's fallacy. Not a subtle version. Not an ambiguous case. A clear, demonstrable, fundamental error in statistical reasoning that had been identified in the academic literature and should have been caught before the trial. He contacted the legal journal. He contacted the Criminal Cases Review Commission, the body in England and Wales responsible for reviewing potential miscarriages of justice. He wrote a formal statistical analysis demonstrating the error in precise mathematical terms. He submitted it with the kind of precision that his 28 years of academic work had equipped him for. He then found, through the journal, a way to contact Vanessa Torres directly. He wrote her a letter. He explained who he was. He explained what he had found. He said, "I believe your conviction rested on a statistical error. I believe I can demonstrate this. I would like to help if you will allow me." Vanessa Torres received the letter on a Tuesday morning in November 2019. She read it standing in the hallway of her flat in Bristol. She read it twice. Then she sat down on the floor of the hallway, which was not something she had done since childhood, and held the letter for a long time. The formal application to the Criminal Cases Review Commission, submitted in early 2020, was accompanied by Dr. Adeyemi's complete statistical analysis, 47 pages demonstrating, with the precision of university-level mathematics, the exact nature and magnitude of the error in Dr. Marsh's original testimony. The CCRC reviewed the application over 8 months. They engaged their own independent statistician, who confirmed Dr. Adeyemi's analysis. They concluded that the statistical error was real, was significant, and constituted a possible miscarriage of justice. In November 2020, the CCRC referred the case to the Court of Appeal. The Court of Appeal heard the case in the spring of 2021. The Crown Prosecution Service, reviewing the case in light of the new analysis, did not vigorously oppose the appeal. Their position was measured. They acknowledged that the statistical evidence presented at trial had been flawed, while arguing that the transaction records and access evidence remained valid. They left the determination of whether the conviction should stand to the court. The Court of Appeal delivered its judgment in June 2021. The conviction was quashed. The court found that the statistical evidence had been a significant and influential component of the prosecution's case. That the jury had been invited to rely on a figure, 1 in 800 million, that was not what it had been presented as. That this constituted a material error that had undermined the fairness of the trial. Vanessa Torres was in a cafe in Bristol when Diana Cross, her attorney, called with the news. She was drinking tea. She put the cup down very carefully, as if it might break, and listened to Diana tell her what the court had decided. She said, "Say it again." Diana said it again. Vanessa sat in the cafe for another hour after she ended the call. She did not leave immediately. She ordered another cup of tea. She looked out of the window at the Bristol street outside, the ordinary city that had continued without her for so long, and she let it be ordinary. She let the ordinary be enough. Vanessa Torres received compensation from the British government under the statutory miscarriage of justice compensation scheme, the maximum available under UK law at the time, assessed in relation to the impact of the conviction on her life and career. Dr. Eleanor Marsh, the statistician whose testimony had been the cornerstone of the conviction, was not prosecuted. She had made a professional error, not a deliberate one. The expert witness immunity that applies in British courts meant she faced no legal liability. She issued a public statement acknowledging the error in her methodology and expressing regret. The Meridian Capital Funds, the £2.3 million that had been identified in the 2002 audit, were never fully accounted for. The internal audit that had identified them had attributed them to Vanessa. After her conviction was quashed, a fresh investigation found that the transactions had originated from credentials that had been compromised in a data breach Meridian had experienced in late 2001. A breach the company had not disclosed at the time, and whose existence had not been available to Vanessa's defense. The actual embezzlement, if that is what it was, has never been conclusively resolved. Vanessa Torres is 58 years old. She lives in Bristol. She has returned to mathematical work, not in finance, which no longer interests her, but in academic consultancy, advising universities and research institutions on statistical methodology. She is, by all accounts, exceptionally good at identifying errors that others miss. This should surprise no one. She has given a number of public lectures on the prosecutor's fallacy and on the use of statistical evidence in courts. She speaks without bitterness, with precision, in the same language of mathematics that was used to destroy 18 years of her life. She has made the language her own again. She was asked, in one of those lectures, what she wanted people to understand about her case. She said, "Numbers are not neutral. They can be correct or they can be wrong. They can be used honestly or they can be misused. And when they are misused in a courtroom, even without malice, even by qualified experts acting in good faith, the consequences are borne entirely by the person on the wrong side of the wrong number." She paused. Then she said, "I was the wrong number. 18 years of my life were the cost of a calculation error. I would like people to understand what that means, not for my sake, but because there will be another wrong number. There will always be another wrong number. And unless we change how we use statistics in courts, the person who carries that number will have no more protection than I had." The room was quiet when she finished. The right kind of quiet, the kind that means something has landed and people are deciding what to do with it.